Your Lordship, I beg to mention item number 25. Item number 25, I am for the petitioner, Your Lordship. The respondent number 4 has filed additional affidavit in counter, Your Lordship. So may I be allowed time to obtain instruction? So Your Lordship may be taken after 2 weeks, Your Lordship.
Item 25.
Yes.
Request made by Mr. P. Sharma. Just stands deferred to be listed after 2 weeks, enabling him to file additional. Reply everything.
Not exactly reply, I will take instruction as to whether reply is
It is instructions on the affidavit filed by the respondents.
obliged.
Lordship, I beg to mention item number 12. On the consent of the other side, kindly give us 2 weeks time.
You're for the
All respondent, Lordship.
item 12 on the request made by MS. Your name?
NB Kaister.
N.
B Kaister.
ND Kaister. The council affidavit the respondent stands deferred to be listed after 2 weeks.
Yes, Lordship.
Please answer.
May I please your Lordship, with the consent of the other side, Lordship, I beg to mention item number 22, your Lordship. Lordship, respondent has filed affidavit, Lordship, so we want to file rejoinder affidavit, Lordship. So Lordship, kindly 2 weeks
Petition.
time, Lordship.
Item 22 referred to be listed after 2 weeks, enabling the council commissioner to file affidavits.
Lordship, rejoinder
Joint
affidavit,
the
Lordship.
affidavit filed with the respondent.
Lordship, respondent is present.
Hmm?
Respondent is also present in this. But
You are appearing for the respondent.
yeah. Rajshekhar, on behalf of Rajshekhar.
Mr. So appears on behalf of. What is your name?
A Kashyap.
A. Kashyap. Appears on behalf of Mr. R. Shekhar.
Please, Lordship.
So with the concern of the petitioner, item number, Lordship, 28.
28.
Yes, Lordship, 28.
Huh.
And
This
the
is
adjourned
for
for day.
mediation. Go for mediation.
Lordship, after 2 weeks, Lordship.
Why?
Lordship, we have prepared the affidavit, Lordship. That means,
No, it is listed for being sent for referring to mediation.
Lordship, in that matter, I have to take instruction, Lordship.
Let-
After 2 weeks, Lordship.
No, let the matter be called up.
Lordship.
Let it be called up, then we'll pass for it.
Lordship, with the consent of other side, I beg to mention item number 21. I am appearing on behalf of Mr. S. Nath. Kindly adjourn for the day.
21 and the request made by the council for the stand to be listed.
May it please your Lordship. Lordship, I beg to mention for listing of 3 writ petitions, Lordship. It hasn't been listed.
Mention it before court number 5. Mention it before court number 5.
Please, Lordship.
Hmm.
Lordship, this matter is regarding promotion. Respondent number 5, 6, 7, and 8 got the promotion.
I think for order. Restored back to 5. Yes, any questions, affidavit? Not filed.
Not filed also.
Not filed. Lordship.
You are seeking promotion to which post?
For senior assistant, and those who got promoted, they are junior than the petitioner, Lordship.
Promotions were made, Lordship, on 1/10,
You have not
2010.
taken steps on respondent 6 to 8.
In fact, Lordship, register post have been done. That was on 2018, Lordship.
And promotions were made, Lordship, on 2010, Lordship.
No, 16 to 2024. There is a judicial order where it says that you have not taken steps. You verify and you tell us, verify and mention the dates when you have taken steps. As per earlier order dated 16 to 2024. Petitioner was granted permission to take steps. As per laws and there, as per earlier order, it is 62/2024, execution was dismissed for non-prosecution, as well as for not taking steps as directed by the laws in the court. Subsequent matters to be restored. However, steps, there is no endorsement by the registry. Step to be taken as for the number 6. Petitioner will take necessary steps on respondent next to it and file evidence to the home to be raised. After that, polls.
I'm left.
I'm last.
Service, the item number 2, my lord, perhaps has become innoxious, my lord.
Item two.
Two.
Item two has become improper.
My lord.
Counsel for the petitioner or instruction. Item four, petition number 4277 has become structured, therefore. Petition of the presidency. Dismissed as no press.
Great.
I am for respondent 1 to 5, my
What
lord.
about the item three?
I am not there.
Who's there? Sir. Yeah, it is.
Where am I?
State respondent with item number. You are appearing in three also.
Yes,
It is item three, you write. As per laws of the board of stated 17 to 25 steps were directed to be taken. As per court's order dated 9/7/2018, steps were directed to be taken. 6 and 7. Subsequently, by order dated 10/3/2025, petitioner was granted time to take steps when the matter is put up. Office note indicates that no fresh steps have been taken on respondent 6 and 7. None also represent. Petitions then dismissed for non-prosecution. In order, they can step.
This is your lordship. Your lordship, the order has been complied with.
Order complied.
Yes, your lordship.
my lord, I will.
Directly contained in the order dated fast within 1 day. That's it, right? To press the petition. The respondent has placed before the board. The communication in July, whereby we've seen that area salary amounting to 1.76901 lakhs. That's released.
Both the petition, my lord, payment have been made to both the petitions.
That's the only matter. The petition. It's court, it's not time to be further. What definition stand close, stand wrong.
No problem.
May I please the lordship? Lordship, in this matter, we'll take fresh steps upon respondent number 1 and 2.
You want to take fresh steps?
Yes, lordship.
Counsel for the petitioner. It's liberty to take fresh steps on respondent part. Prayer being not of big deal. That's not approved. request as referred to be listed after 4 weeks, enabling the company to take such steps.
Blessed.
Made, your lordship. In this case, the state has preferred a writ appeal against the order of the writ petition, your lordship, dated 29/2024. The same is pending, your lordship. It has been numbered as writ appeal number 108 of 2025. The appeal is admitted for hearing, your lordship.
And the writ petitioner was compulsorily retired. Right,
That the appeal has been preferred.
Appeal has been preferred and there is an interim stay also in the appeal. Lordship, may I kindly take mention the name of the number of the writ appeal. Writ appeal 46 of 2025.
Third counsel for the parties, which is submitted in the bar. That writ appeal has been preferred by the state
My lord,
against the judgment and order dated tomorrow, passed in WBC. Being writ appeal number
46 of 2025,
46 of 2025. So it's submitted that by order dated
17 to 25.
17 to 2025. The
Appeal was admitted.
The appeal was admitted and the order passed by the court and bench. By the order dated, judgment and order dated 12/9/24.
My lord,
Passed in WBC 4-5/8 of
passed in WPC 4258
in state.
by the state. State, man, yes.
Accordingly, that this contempt petition deferred to be listed after 8 weeks.
Very grateful, your lordship.
May it please the lordship. On the last occasion, lordship had asked me to place the judgment wherein regard that the parallel proceeding. My lord, at paragraph 15, it's the division bench judgment, man. May I read, man? When a court is in session of a matter, an administrative authority cannot start a parallel proceeding on the very same subject matter as its own ipse dixit and record a finding on the issues. If such an action is taken, the same will amount to directly interfering with the dispensation of justice by the court of law. We have no hesitation to hold that Assistant Registrar of Cooperative Society, Hujai, clearly translated his authority in venturing to dabble in a matter which is subjudiced before this court. Clearly, this is an instance of an authority trying to overreach the orders of this court. The order dated so-and-so being patently illegal without jurisdiction, finding records in the said orders are of no consequences. My lord, I'm relying on this judgment because, my lord, my transfer order, I had challenged the transfer order, and when the notice was issued in the transfer order, I had prayed for a stay, but the stay was not given because I had already joined my transferable post. However, my lord, due to my lords is aware of that the transfer order cannot be detrimental to the career advancement of the candidate. And thereafter, when notice was issued and when the steps was delivered, they take a steps where they withdraw the transfer order and they attach me to the district of Jorhat, where they cannot do, my lord. Because if as a district establishment under the Act, under the Assam Civil Rules, I can only be attached inside the district, not outside the district, my lord. Being an employee of the Secretariat, my lord. And that is why I have brought this on record, my lord.
You read para 4.
My lord.
Of the judgment.
Upon hearing the counsel, a petitioner, learned standing counsel, and a respondent aforesaid of this court by an order dated while issuing notice returnable and posting, directed the status quo as on date regarding holding of the office of the chairman of the society be maintained till the next date. I'm absolutely agreeable, my lord. But the finding, my lord, what has happened in my case?
this judgment you are referring
Yes, my lord.
is on the ground that there was a status quo order.
Yes, my lord.
But in spite of that, you went ahead
Yes, my lord.
and
But
decided on a parallel, by way of a
the parallel proceeding. But in my case, my
In
lord.
your case, there is no interim order.
No, I absolutely agree, my lord. There is no interim order because, my lord, what has happened, my lord, if produce my writ petition.
We permitted you to refer to a citation or an authority to show
Yes,
that notwithstanding there being an interim order.
absolutely, my lord.
Citation is pending.
No, my lord, absolutely, my lord. May I just,
Proceeding can,
may I
there
just
cannot
submit?
be an alteration.
Exactly. my lord.
Absolutely, may I just submit, my lord? My lord, what has happened in my case is this, that I was transferred. The day I was transferred, that day only the release order was issued to me. And as such, I had to join the post of District of Jorhat. Thereafter, my lord, what happened? I filed a writ petition. Because I had joined the transferable post, the question of stay did not arise. That is why the learned single judge, while passing and noticing the order, it had directed that because there was a detrimental to the seniority and the effect, the matter would be there. Now, what they have done in the order thereafter, my lord, they have withdrawn their transfer order, and my lord, the transfer order they have withdrawn, and they have attached to me, my lord. They have attached me from district of Majuli to district of Jorhat. So they themselves have resigned to the order of transfer, my lord, which was under the jurisdiction, which on the question of the illegality, my lord. What they could not do from directly, they are doing it indirectly, my lord.
There was no interim order.
My lord, the question of the interim order would only arise if I would not have joined the post.
Therefore,
Because I have not joined the post, because my lord may see the circumstantially how I was transferred.
there was a transfer order.
Absolutely, my lord.
You challenged this order, but at that time you had already joined.
Yes.
Right?
Yes, my lord.
Now that order has been altered and you have been given attachment order.
It has not been altered, my lord. It has been removed. And now what has happened, my lord?
Where is that order letter?
Yes, my lord.
Cancel.
Cancel. The transfer order stands cancelled. So the moment the transfer order stands cancelled, I should be reverted back to my original post.
No.
Therefore, you should challenge this order.
Yes, my,
Yes.
that's why through an I have challenged it, my lord.
By IA, he cannot challenge it.
You can challenge it by an IA, but you may ponder over it whether an IA or a separate writ petition.
My lord, may at this stage may issue notice, my lord, on this
Will
regard.
issue notice.
My lord.
We will decide to issue an interim order on this.
My
Issue
lord,
notice.
my lord, may I just submit? I absolutely may I just for this present to the court, my lord. A transfer order was there. I was released. I joined to the post. I filed a writ petition. The order of the court stated that because you have joined, as such, the interim order does not arise. I communicated the order. Thereafter, my lord, they withdrew the order. Now, my lord, the Supreme Court in the Apex Court on Lord's own judgment clearly states that a transfer order cannot affect the service detrimental interest of service carrier. Now, when I'm as per the bite of the law of the
Where
secretariat,
is the transfer order today?
yes, there is no transfer order, but they have attached me, my lord.
That's right. So it becomes the new course of action.
Yes, and as such, I have filed the IA, my lord, because they have not given a revert back order.
It's your call. File IA or an affidavit.
Absolutely, my lord.
But it becomes the new course of action.
Yes.
Must.
Whether you can challenge it by way of an IA, it has to be decided.
As your lordship, my lord, may I?
We are not convinced that this is not a case of mere alteration. Let us say you have been given a transfer order from A to B.
Yes,
You have
absolutely.
joined in B.
Yes, ma'am.
Thereafter, the order was altered and you have been now set in C
Yes.
of the same order.
Yes, my lord.
This is the case where the earlier order stood cancel.
Cancel.
Instead, some other order has been issued where you are shown to be attached to.
But here in my case, my lord, if lordship.
Therefore, the question would be whether by way of an order of attachment this can be done. Whether it, as you say, that it affects your seniority, whether it can.
Yes,
be
my
done,
lord.
other issues to be decided.
My lord, and the second thing that I'm pointing out in my pleading is that when you have already passed a transfer order, when you are reverting and when you're taking back the transfer order, there should be a reversion. There should be an order of reversion. Me back to the post.
But Mr. S.P. Sharma, let it is an IA. So the applicant, Mr. Sharma, here represents the opposite party respondent. The Since Mr. Sukia represents the
4 and 5, my lord.
only 4 and 5.
Yes, my lord.
What about the others?
GADA, my lord, represented by Fukon. He hasn't come, my lord. His name is not shown, actually.
Have you served copies on the other council?
Yes, my lord. I have-
GADA.
Yes, my lord. I
You
have.
you're a government advocate.
My lord,
You're a government advocate.
I can otherwise,
We'll permit.
there is a standing
Yeah,
council,
explain
why
on
I
behalf
should
of
take the
all
burden?
the respondents. And Chairman is the way extra copies be published within a period of 1 week from today. Prayer for interim be considered after on the next interim. And what to do in the writ petition?
My lord, the writ petition still is I let the writ petition I be heard together, my lord. That's what.
What is there to be heard in the writ petition?
My
Nothing, my
lord,
lord.
my lord, that is where I was in.
That has already been cancelled, my lord,
Well,
in
it's
first class.
dispute order.
Yes, my lord, but there is no revision order, my lord. The moment there is no revision order, my seniority, my positioning back to my original will be affected, my lord.
All right. Both the writ petition and the still after the return. It's after 2 weeks. Mr. Gutia,
2 weeks.
get your instruction. 2 weeks.
2 weeks, my lord. Obliged, my lord.
My pleasure, lords.
Yes.
Lordship, in this case, lordship, in different occasions, lordship, once the elementary education, lordship, reflects to the secondary educations that they are the appropriate authority, lordship. Earlier that, lordship, elementary department was directed to take instruction, lordship.
Yes, elementary education.
That's why I have received instruction, my lord.
What do you want to do? What is your prayer here? But why education matter is here?
Education, lordship.
This is education matter.
Yes, education.
It should go before the correct bench.
Bench to Bench to
8 and 9.
It is shown as bench 3.
Yeah, my lord, Accountant General is also the party.
What is your prayer here?
Lordship, may kindly come to the page number 29, Annex K. This was the last communication, lordship.
What is your prayer?
Lordship, for releasing, lordship, compassionate family pension, lordship, area of compassionate family pension and other service benefits relating to the service of the petitioner's father, lordship. Some gap period of services are there, lordship. Those services are to be regularized, lordship.
What is your instructions?
Lord, as per instruction, it's that secondary department is the authority to.
Secondary education.
Yes,
Secondary education is already
My lord,
part-
I am appearing for secondary education department, my lord. Here I am also received one instruction and from our end, my lord, it is forwarded to the district elementary education, my lord.
But elementary says it is secondary.
Yes, my lord. So, my lord, some time is required to mitigate the matter, my lord.
Time for what? You have to regularize the services.
My lord, initially he was joined as a district elementary officer under the elementary education.
Then
Lordship, may kindly come to the page number 29, lordship. This was the last communication.
pension paper submitted by the secondary education lordship before the accountant general, and thereafter
Page number 29, what is that?
page number 29, lordship. After receiving the pension papers, lordship, perhaps lordship, the accountant general return it back to the secondary education for mitigating the observations, lordship.
Where is the revocation of the suspension order?
Revocation of suspension order, lordship.
Is it here?
Is not annexed, lordship.
We wanted to see who passed the order. Is the order of suspension there? Revocation is there, page number 26.
26, lordship.
It is done by secondary education department.
Lordship. Secondary education.
Yes, secondary.
My lord, referring to that letter and the notification dated to January 2015, we have to take fresh instruction from the department, my lord. My lord, in this regard, some time is required, my lord.
But council for parties, Mr.
You, Sharma?
E. Sharma, council for secondary. Raise for further thing completed with regard to the required steps. With regard to the steps required to be taken. With respect to the period 1/3/2001 to 8/3/2009. For which period the services of the petitioner not regularized. Also, the mode of treatment for the suspension period with effect from 8/8/2012 4/1/2015. Which is not reflected in the order dated 2nd January 2015 while revoking the suspension order. If these instructions be completed and placed before the court. Matters can be referred to be listed after 4 weeks.
A date may be fixed.
After 4 weeks. 16th or 17th of October.
Bless you.
Letter pertains to non-payment of arrears salary, madam. Also, will kindly see the last order.
Yes.
My non-burial certificate has been issued, madam.
Non-royal issued.
Yes, my lord.
Issued to whom? Treasury office.
Yes.
Is issued.
Yes,
Then
but till date, madam, we have not received that amount.
it is issued on 16/5. 16/5. You get your instructions
Yes.
from this.
My lord will fix it next month's month.
Yes, after 2 weeks.
My lord.
Because the report is the council for the elementary education has placed before the court the non-royal certificate issued by the treasury of its district elementary education office in Torong, although in terms of the last order dated 18/6/25. Placed after 2 weeks.
Can a date be fixed, madam?
After 2 weeks. 28th of July.
My lord.
Sorry, 30th of July.
My lord.
Last occasion, instruction of call from the PNA department. We believe all, GPF money was on release by the, GPF money was on release. GPF was on release.
Lordship, the proposal is being prepared, it is in process, it will be submitted by today or tomorrow. Although it has been stated by the video that
It is prepared by whom?
the video,
Video. Submitted before whom?
AG.
AG. And then how many days thereafter?
10 days?
10 days.
So last 2023, this is happening. Huh.
But
Second all of litigation, this is.
from the instructions, it appears that the wheels are moving.
Yes.
Little slowly, but they're moving. All right, Mr. S.R. Gugoi for the petitioner, Mr. P. Sharma for Accountant General, Mr.
AK Ghosh.
A.K. Ghosh for
PNRD.
PNRD, Mr. Chutia for
My lord, my instruction is, my lord, this petitioner is not related to this department, pension department. Our name may be strike out.
You were there for so long, why do you want to abandon it?
No, my lord, this is the instruction, they says that they are pending or, this department is paying director pension Assam
That's
Airport.
all right,
Authority.
we'll record your name, Mr.
Our name may be
Chutia
strike out,
for-
my lord. What is the
Chutia
instruction?
appears for the pension department. And page 4 for respondents 3 and 8. So Mr. Ghosh submits that the GPF proposal. What is that? What proposal?
GPF proposal.
General Provident Fund.
GPF proposal has been processed and is likely to be submitted by the BDO before the Accountant General within a day or two. And thereafter, within 2 weeks' time, the amount can be released to the petitioner as submitted by Mr. P. Sharma.
We can authorize the payment, my lord, will not be.
The steps will be taken for authorizing for release of the payment as submitted by Mr. P. Sharma. Mr. P.C. Sutia, representing the
2 and 5.
Respondents 2 and 5, on instruction submits that pension Directorate of Pension Assam is not a necessary party in the same proceeding as the petitioner, as the state department is empowered to authorize pensionary benefits only to teaching and non-teaching staff of provincial line school, PNRD department and junior colleges. PNRD is there.
Yes, my lord, they will sanction, my lord.
No, my lord.
Thing here is, my lord, they have already sanctioned, probably that's why that instruction has come.
You have mentioned here PNRD.
Yeah.
The instruction says, my lord, they are not dealing with.
You have not seen the instruction.
So let it be,
Strike out the last.
let it be continued, my lord. This instruction, my lord, how?
Lordship, a date may be fixed.
List after we list on
7th of August.
8th of August.
Mass supplies.
Hey, please, Your Lordship. In attending, I have received the counter affidavit manner with signature. I am going to file manner.
Mr. B. Purkashta for the petitioner, M.S. A. Gayan for the CPC submits that counter affidavit to be filed during the course of the day
Giving this by tomorrow, my love, because I have some correction is
within
there.
2 days.
Yes.
So, taking their considered submissions to the consideration, matters stands deferred to be listed after 3 weeks, enabling the petitioner to file rejoinder affidavit in the meantime. Just after 3 weeks.
Master.
Date, my lord.
File your affidavit, let the pleadings be exchanged, then you fix a date.
Master.
My lord. Last citizen.
Yes.
My lord, here I am appearing on behalf of Accountant General, my lord. Here already we have issued PPO and the GPF. And the DCRG could not be paid due to he is having house building advance. That is to be adjusted there only. The department is to do this way. In Lordship, last order I have seen, affidavit is required to be filed in this effect. Because due to my health condition, I could not do. Now I have said, yes, understand. If the affidavit is required to be filed, that this aspect, because I can put the notice before your lordship. PPO already we have issued. Then the GPF we have issued. DCRG could not be issued because of this house building advance to be adjusted.
My lord, regarding house building advance, I want to make it clear, my lord. I had drawn my monthly salaries up to February 2008, my lord. And during that period, by house building,
Let it be brought on record.
yes, my lord.
Let it.
Subject to the deduction, my lord. If I'm liable to pay anything.
Let this information be brought on record.
My lord, kindly,
My lord,
I'm
my
sorry.
lord.
Let this information be brought on record.
Information
Let
to
him file the
Yes,
affidavit.
I have stated in my petition also.
মোৰ ৰেকৰ্ডটো আনিব দিছে মই যে দিলো এতিয়া সেইটো লৰ্ডশ্বিপ উইল ৰেকৰ্ড ইট মাই চাবমিশন ইনফৰমেশ্যন
You need to record.
Yes,
It
then
will be recorded, my lord.
what about
Yes,
forest?
I am seeking, my lord, just 10 more days, my lord. I am preparing the affidavit. I'll file it in 10 days.
My lord, last occasion, again, lordship, on the last order, your lordship on provision, there are so many days they have taken.
Last chance, my lord. I'm already done with the affidavit.
House buildings. Actually, my lord, my respectful submission, what happened, they have very small matter actually, petty matter, they have made complicated. Only after I have been retired from my service on 31st December 2017. Now retirement benefits should be given. In the meantime, a departmental inquiry, as per the first WPC case, they were to complete within outer limit of 3 months. They could not complete. After about 1 year, they have completed the expert inquiry report. And that no consequential report subsequently, they have closed departmental inquiry regarding the public engineering department. Now, my lord, as per that inquiry report, my lord, I have received a nominal amount of salary, a year's salary. But they have not calculated the amount as per the ROP rules 2010 and 2017. That is my respectful submission. I have this is a voluminous petition, no doubt, my lord, because I have calculated the amount, how I am entitled to receive. They have already received. And it is very easy. As per that calculation, they should submit.
Mr. S. Sharma.
That's why I am suffering a lot, my lord. For 9 years, 10 years, I have not received any salary.
Public Health Engineering, while Mr. Borua, C. Borua appears for
Accountant General, my lord, that is for notes 6 and 7.
6 and 7.
My lord, copy may be furnished about it.
Order
As per the instructions received,
order of proposal.
Mr.
Order
The
reflect
basis of instructions received, Mr. Borua submits that upon receipt of pension papers,
Very nominal amount, that may be deducted from
withdrawal application, the receipt of pension papers, then withdrawal application
to হ'ব দিয়ক না
from the parent department. The Accountant General is already
Very
given the
important.
PPO and the GPF final payment authority for making payment. However,
পাইছে
the DCRG amount would not be released on account of outstanding house building advance. He therefore submits that these instructions be permitted to be brought on record. He prays for a further week's time.
for filing affidavit to do this effect
No,
If
no,
I-
we don't know what affidavit you want to file. You said you want to file an affidavit.
No, no, only I have to file this, only this, is this point to be being by affidavit, your
We
lordship?
are not saying you file something more. We are asking you whether you want to file an affidavit or not.
I'll be on record by this.
How
Yes,
much time? 1 week?
yes, 10 days.
And what about Mr.
I'll also, my lord, in filing, in 10 days.
B6, if a deed by the affidavit within 10 days, from circular prayer made by the PH department.
The money recorded.
Madam, date may be fixed, my lord. Then, actually,
Yeah,
madam,
No further opportunity will be enlarged with the respondents to file their.
Oblige me, Lord. Yep.
This again, after 10 days.
10 days.
madam, date may be fixed. In August, my lord, lordship may fix that I have no this one, my lord. On 18th August.
18th
18th August.
August. 18th August.
18th August.
I can do it.
not be available.
Instruction to do.
In
Madam,
the event
madam,
of
it
the
could be-
district, I
Loan is
petition
giving.
the authority to file. Yes.
A copy may be
No, I'll file affidavit.
He'll file
He'll
it.
get it affidavit. Why copy?
always sufficient.
Arey, affidavit I'll file, my lord, I'll give affidavit.
For filing affidavit. Possible.
Lordship, in this matter, Lordship, my affidavit is almost ready, Lordship. I'm praying for 2 weeks' time now.
Any objections?
No.
Mr. Ray Biswas. I have. Okay. Praise for further 2 weeks' time. By the list this matter then after 2 weeks. Enabling the respondents to file their.
Lordship, if possible, a date may be fixed.
Uh, 6th of August.
Oblige, Lordship. Oblige.
Yes.
May it please your lordship, on the last occasion, your lordship, my learned friend has prayed before this honorable court to file an affidavit.
Affidavit filed. Affidavit not filed.
But if it is from the state, we have not filed, man. This writ petition has been filed because his certificate of practice was not renewed. If you lordship go to the act, my lord, they don't have any enforceable right as such. Act says they may renew.
Already. Already.
So,
এখন লোক না, এখন লোক।
5 years, 2015 to that person.
দিতে হবে।
2015 person. Well, to which put it at right. Standing.
Section 5, lordship kindly.
Section 5.
5 says entries of names in the register in issue or renewal of certificates of practice. Every notary who intends to practice as such may, on payment of the government appointing him of the prescribed fee, if any, be entitled to have his name entered in the register maintained by that government under Section 4 and to a certificate authorizing him to practice for a period of 5 years from the date on which the certificate is issued to him. Subsection 2 is relevant, my lord. Government appointing notary may, on receipt of an application and the prescribed fee, renew the certificate of practice of any notary for a period of 5 years at a time. So, as such, there is no enforceable right that it has to be automatically renewed and it has to be renewed.
No, but if you don't renew it,
My lord.
then some reasons are necessary. Why not renew?
My submission will be if it says that
This is an
they
act.
may.
I think.
Otherwise, man, it will be a never-ending affair. It's not a government job, my lord.
I think from 1952.
My lord.
From 1952.
My lord.
A lot of water has flowed.
No, that is there. Well, what I'm saying is, my lord, a person once appointed as a notary,
But he is entitled to know the reasons why he's,
well, it's not a government job that for some reason he's been dismissed or removed. They have not renewed it. Are they? Well, I'm just
no.
putting a question to myself. Are they entitled to automatic or renewal or any notice?
They may not be entitled to renewal,
Well,
but at least they're entitled to know the reasons why their renewal is not there. Some reason. The authority who may or may not.
my lord, your lordship is aware for the state government there is a limited scope that so many persons will be appointed.
Whatever it may be.
Now, if one person once appointed, if he continues, others will not get any chance, my lord. If that is the so, my lord. If he has to be shown reasons, he has to be given an opportunity. In no case.
The statute that.
The statute says they may, on receipt of an application, do it. They may not do it.
May not do it,
My
but
lord.
you must give some reasons because you had given him.
My lord, it is not a case where that because of some failure in his performance or for any other reason, because otherwise if they go in that line, my lord, it will be a schematic thing. Then he will say that you please hold an inquiry and prove your charges. It's not a government job, my lord. No enforceable right is there. You have been appointed for 5 years. Others, he has been there for 2 terms.
Saying enforceable right is to have his license extended.
My lord.
We agree with you that he may not have an enforceable right. He is strictly entitled to it. The reasons as to why he is not considered fit to be extended. There must be some reason. So the officer who has refused to extend it must report some reason.
No, but extension, he is not, if he is entitled to extension otherwise, and then he is not extended, then he can say that why you have not extended. But if it says that they may renew it, they may not renew it. There are others who are in the hope of getting this opportunity of acting as a notary.
This is a self-defeating argument. On one end, you say it is not a government.
No, well, he has been there for 2 terms.
He may be there for endless amount of terms, but that must be recorded in the reason that you have given him. This is do they get any payment from the state?
No, no.
What benefit do they get from the state? Nothing.
Benefit is the appointment itself.
But they are not getting any financial or pecuniary benefit.
No.
So this is nothing but a.
What I am trying to impress upon your lordship, supposing the government says that there has been failure on your part, there is any misconduct.
We accept all your arguments with regard to enforceability. He has no enforceable right. But it is entitled to a reason.
My only one thing is subject to a lawsuit consideration. One thing I'm saying that if the government decides that no, a person has been given the opportunity of remaining there as a notary for 2 terms for 5 plus 5, 10 years, and thereafter we'll give it to some other person without any reason. If they decide that no, this time we'll give it to some other person, they can do it. Otherwise, what they are saying is that you kindly show us the reason why I have been removed, as if there is any charge of misconduct against him. These things cannot be done by the state, because if once the state says no, there was a misconduct, then the question will come, you hold an inquiry. It's a completely in a different.
Then you'll have to interpret section 5(2).
My lord. That's what I'm saying. 5(2) is very.
This may has to be understood.
My lord.
That whether the renewal of the license is required by looking into his conduct, or whether there is any, let us say, criminal cases pending, days that government may decide not to renew. Ordinarily, it is expected the government will renew unless there is a good reason not to renew.
That is what
You may even say that yes, this particular place has got more than enough notaries. We don't want to renew your. Would be a good reason.
What I'm trying to say is, if that is the line taken, then the ultimate concept will be that once a person is appointed as a notary, he will continue for.
And you have to give some meaning to a central statute. Why is the statute there?
That is why it says they may renew it, meaning thereby that they may not renew it.
They may not.
It is discretionary.
This may not must have a preceding justiciable reason. They don't must be on the ground. It can be.
Well, my humble
and pencils of the officer who may or may not renew.
Well, my humble submission before lordship will be that if we the the language of this section is such that it doesn't actually, my lord, make it imperative on the authority
We
to
agree
record a
with you.
reason.
Why are you, we absolutely agree with you that it does not mandate renewal.
My lord,
There is no enforceable right. But if you choose not to renew,
my lord.
there must be some reason. You can
That-
say.
my lord, that is what I am saying.
You
If
can
the,
say
my lord.
that the reasons are not even required under the act to be communicated. But it must be there somewhere on the record for the court to see at least. What were the reasons for not renewing? You may produce the records if you want.
No record as such, then, my lord, you will let us file an affidavit then, my lord, on the question of law.
Question of law doesn't require an affidavit to be filed. You can argue it.
I can, my lord, this is what I'm, my lord, in my humble understanding of the provisions, my lord, it doesn't say that he is entitled to any renewal.
There you go again. We agree with you. It's
My
not
lord.
entitled.
My lord,
But the act says government appointing notary may on receive, may renew,
my lord,
may
me,
not renew.
yes,
We agree. But there has to be a decision prior to that taken by that authority. So I believe that we are at least entitled to know the reason. Yes, Mr. Devi, what do you say?
Absolutely, Your Lordship, is right.
Absolutely what?
Removal of names from register, Your Lordship, section 10, it makes it very clear, Your Lordship, of the Notaries Act. May I read? The government appointing any notary may by order remove from the register maintained by it under section 4 the name of the notary if he makes a request to that effect or has not paid any prescribed fee required to be paid by him or is an undischarged insolvent or has been found upon inquiry in the prescribed manner to be guilty of such professional or other misconduct as in the opinion of the government renders him unfit to practice as a notary, is convicted by any court for an offence involving moral turpitude or does not get his certificate of practice renewed. So all these conditions are there in the act itself, Your Lordship. This is statutory. And if Your Lordship may kindly peruse the order at page 32 of my writ petition, Your Lordship. May I read? In exercise of the powers conferred under section 3 and section 10 of the Notaries Act 1952, the government of Assam is pleased to reject the renewal of practice of notary certificate of Sri Sanjeev Lawkar, Notary Public of Tinsukia District, Assam, bearing register number so-and-so, file number so-and-so, issued on 5/10/1/2015, tendered by this letter number nil dated 19/11/2023. So no reasons have been cited, Your Lordship. These are the.
my lord, my lordship has seen section 10, my lord. Section 10 will make it clear that only in the case of a removal, my lord, removal, as your lordship is aware, my lord, involves a stigma. That is why it says government appointing any authority, any notary may, by order, remove from the register maintained by it under section 4 the name of the notary if he makes a request to that effect or etc. Then it says is D.
F.
D also, my lord, has been found upon inquiry in the prescribed manner to do guilty to be.
This is not the case here.
No, that's what I'm saying, my lord. This is not the case here.
So it is covered by F.
Doesn't get his certificate of practice renewed. Yes. If he, that's what I'm saying, Mali. If he doesn't, supposing it's covered by F, if he doesn't renew it himself, then his name will be removed. And here is a case not of removal, my lord. Of non-renewal.
Non-renewal.
Yes.
Subsequently.
Non-renewal is not amounting to removal. Removal means it carries with it the element of stigma. So if it is a simple non-renewal, no element of stigma is there involved.
But the question is
My lord.
that
The question ultimately will be whether non-renewal also requires recording of reason.
otherwise you have to give some, you have to ascribe some meaning to section.
My submission subject to your lordship's further consideration and my lord further argument. When we read the provisions as it is in section 5 subsection 2, the entire discretion with this is with the state, they may or may not renew. And for that possibly, my lord, no reasons are required to be recorded.
May not be communicated, but there must be somebody who takes a call why this license should not be renewed. Where does the person get the authority to decide what he likes to do, what he doesn't like? It has to be derived from section 5(2). 5(2) does not prohibit recording of reasons or showing at least. It is implicit that there must be some reason where the authority may or may not redo. But the government is not a private institution that you dislike somebody, you throw in.
He does it on different card. Full card.
You file your affidavit if you want. And Mr. Devi,
Yes,
you
sir.
need to convince the court and
I had submitted my application for renewal prior to the date of my.
oh, but if you stay with the objections raised by the London additionally, that
No,
doesn't mandate recording of reasons or communicating reasons. You have no enforceable right.
No,
So
it-
why a writ?
It's a discretionary power, your lordship, but they are using it arbitrarily, if I may respectfully submit, your
That
lordship.
is your submission. What is the basis for
Because-
raising this?
Rule 8, your lordship, 8B. In fact, Rule 8, appointment of a notary.
Late.
4, sub-rule 4, your lordship.
Yes.
Where the application is, may I read, your lordship? Where the application is allowed, the appropriate government shall appoint the applicant as a notary and direct his name to be entered in the register of notaries maintained by that government under section 4 of the Act, and issue to him a certificate on payment of prescribed fee authorizing him to practice in the area to which the application relates to, or in such part thereof as the appropriate government may specify in the certificate as a notary for a period of 5 years from the date of which the certificate is issued to him. Then 8B, your lordship, Rule 8B, renewal of certificate of practice. The certificate of practice issued under sub-rule 4 of Rule 8 may be renewed for a further period of 5 years on payment of prescribed fee. An application for renewal of certificate of practice shall be submitted online in Form 15 of the appropriate government before 6 months from the date of expiry of its period, provided that the appropriate government may, after considering the reasons stated in the application, relax the condition of submission of application for renewal of certificate of practice before the said period of 6 months, provided further that where an application for renewal of certificate of practice is received within 1 year after the date of expiry of its period of validity, the appropriate government may, after considering the reasons stated in the application, renew the certificate of practice with effect from the date of expiry of its period of validity. So the proof of is also there, and still your lordship is the first line 8B, the certificate of practice issued under sub-rule 4 of Rule 8 may be renewed for a further period of 5 years. Now this may, your lordship, in my respectful submission, according to my learned counsel, your lordship, senior counsel, this may is that the government has the discretion, but the may should be treated as shall, your lordship.
Show us some authority on what basis you are.
Your lordship, AI 2019, this is AI 2019, Uttarakhand, 155. I'm relying from paragraph 14 to paragraph 30, your lordship. May I read, your lordship?
Yes.
Section 5 of the Act relates to the entry of name. This is the same case, your lordship, where the renew was not, where the certificate was not renewed, your lordship.
You are reading from para?
Paragraph 14, your lordship. Section 5 of, may I read? Have your lordship got it? Section 5 of the Act relates to the entry of the name in the register and issue of renewal of certificate of practice. Under subsection 1 thereof, every notary who intends to practice as such may, on payment to the government appointing him or the prescribed fee, if any, be entitled to have his name entered in the registered name maintained by the government under section 4, and B, to a certificate authorizing him to practice for a period of 5 years from the date on which the certificate is issued to him. Section 5.2 enables the government appointing the notary on receipt of an application and the prescribed fee to renew the certificate of practice of any notary for a period of 5 years at a time. The discretion conferred on the government under Section 5.2 of the Act is to renew the certificate of practice of any notary for a period of not more than 5 years at a time. While no notary can seek renewal of his notary certificate for a period of more than 5 years, it is always open to him before expiry of his earlier term of 5 years to seek renewal for a further period of 5 years. On payment of the prescribed fee on any such request being made, the government is required to consider whether or not to renew the certificate of the said person. Section 9 of the Act bars practice without the certificate under subsection 1 thereof, subject to the provisions of this section. No person shall practice as a notary or do any notarial act under the official seal of a notary unless he holds a certificate of practice in force issued to him under Section 5 of the Act. Section 10 relates to removal of the names from the register, and clause F thereunder confers power on the government appointing any notary by order to remove from the register maintained by it under Section 4 of the name of the notary if he does not get his certificate of practice renewed. We are in agreement with the opinion of the learned single judge that removal of the name from the register under subsection 10F of the Act is merely a consequence of the certificate of practice not being renewed. While the government undoubtedly has the power to delete the name of a notary from the register on expiry of his term of office of 5 years, in case the certificate of practice is not renewed, the question which necessitates examination is whether any right is conferred on a notary to seek renewal of his certificate on expiry of his earlier term. It is useful in this context to take note of a relevant provision of the rules. Rule 3, which prescribes the qualification for appointment as a notary, stipulates that no person shall be eligible for appointment as a notary unless on the date of the application for such appointment he fulfilled the qualification stipulated in clause A to C. The qualification prescribed in section 3A is that the person should have been in practice for at least for a period of 10 years. Rule 4 relates to the application for appointment as a notary. Rule 8.4 stipulates that where the application is allowed, the approved government shall appoint the applicant as a notary and direct his name to be entered in the register of notaries maintained by the government under section 4 of the Act and issue to him a certificate on payment of the prescribed fee. Rule 8.3 relates to renewal of the certificate of practice and stipulates that the certificate of practice issued under sub-rule 4 of Rule 8 may be renewed for a further period of 5 years on payment of the prescribed fee, and an application for renewal of the certificate of practice shall be submitted to the appropriate government before 6 months from the date of expiry of the period of its validity. A conjoint reading of section 5.2 of the Act with Rule 8B of the rules make it clear that the notary is entitled to seek renewal of his notary certificate on expiry of his terms of service. The only restriction in granting such renewal is that the period of renewal cannot extend beyond a period of 5 years at a time. A notary is not disabled from making an application to the state government to renew his certificate even in cases where it was renewed earlier for a period of 5 years. Absence of specific procedure being prescribed in the rules for considering requests for renewal may necessitate the interference that the procedure prescribed for appointment under Rule 4 to 8 of the rules should be followed even in the cases where renewal of the certificate is sought. It is unnecessary for us to examine this aspect in the present proceeding, as we are satisfied that the order impeding the writ petition necessitates being set aside on the other grounds. Section 5.2 no doubt confers discretion on the government to renew the certificate of practice of notary for a period of 5 years at a time. Such discretion either to renew or not to renew the notary certificate cannot be exercised on the whims and fancies of the concerned authorities and must accord with reasons. Fairness in action is a prerequisite for proper exercise of discretion, and the concerned authorities should take a decision for just and valid reasons. What the rule of law demands is not that wide discretionary power should be eliminated, but the law should control its exercise. The first requirement in the recognition that all powers has legal limits. Thus, the next requirement, no less vital, is that the court should draw those limits in a way which strikes the most suitable balance between executive efficiency and legal profession of the citizen. The legislature often confers upon public authorities power which of their face may seem absolute and arbitrary, but arbitrary powers and unfettered discretion are what the courts refuse to countenance. Administrative law, so there is a room for exercise of discretion within the operation of the rule of law, even though it should be restricted to the extent of necessary for proper governments. Supreme Court Advocates on Record Association and another versus Union of India, Air 1994, Supreme Court SC 268. Every activity of a public authority must be informed by reasons and guided by public interest. All exercise of discretion or power by public authorities must be judged by that standard. Messrs. Dwarkadas, Maftaria and Sons versus Board Trustee on Port, 1989, 3 SCC 293. The concept of unfettered discretion is inappropriate to public authority which possesses power solely in order that it may be used them for a public good. Administrative law, so and so, a public authority must act reasonably and in good faith and upon lawful and relevant grounds of public interest. Then paragraph 21, discretion should be exercised according to the rules of reasons and justice, not according to private opinion, according to law and not humor. It should not be arbitrary, vague and fanciful, but legal and regular. And it must be exercised with the limit to which an honest man competent to the discharge of his office ought to confine himself. Administrative law, so and so. Whenever a statute or a statutory rule confers power on a statutory authority, howsoever wide it may be, such discretion should be exercised reasonably. Consumer Action Group and another versus State of Tamil Nadu and others, 2007 SCC 425. Statutory power to be exercised for a public purpose is conferred as it were upon trust, not absolutely. In a system based on the rule of law, unfettered discretion is contradiction in terms. To say paragraph 22, Your Lordship, the discretionary powers conferred upon public authorities is not absolute even within its apparent boundaries, but is subject to general legal limitations. These limitations are expressed in a variety of different ways, as by saying that discretion must be exercised reasonably and in good faith, that relevant consideration alone must be taken into account, or that the decision must not be arbitrary or capricious. They can all be compromised by saying that the discretion must be exercised in the manner intended by the Empowering Act. When a wide power is vested in the authority, it should be exercised with circumspection. Greater the power, greater should be the caution. A discretionary power which is capable of being exercised arbitrarily is not permitted by Article 14 of the Constitution of India, Consumer Action Group. The legislature can never be taken to have intended to give an statutory body a power to act on bad faith or to abuse its power. The discretion of a statutory authority is not unfettered and should be exercised according to law. That means at least this: the statutory authority must be guided by relevant considerations, not by irrelevant ones. If its decision is influenced by extraneous considerations, which it ought to have taken into account, then the decisions cannot stand, no matter what the statutory authority may have acted in good faith. Nevertheless, the decision will be set aside. There is, in principle, no such thing as unreviewable administrative discretion, which should be just as much as contradiction in terms of an unfettered discretion.
There are 30 appears to be on the page. Fact.
In this, my lord, in this case, Lordship will find it page 32.
Each case, present case.
Present case. Section 10 was invoked. But specifically, which part of section 10 is invoked is not there.
Time blank.
10 different. 10 different. Section 10 to remove it.
You call for the records. That is the better way to see. Or if you want to file an affidavit, you are entitled to file an affidavit.
Let us file an affidavit.
Huh?
Let us file an affidavit.
We'll have to hear this matter. Personally, example from Abid, Mr. D. Muzumdar, at the latest expert. It's 3 weeks left. Where maybe it's taken up with 2 weeks. Because your affidavit reflects the reason it is all right, then otherwise we'll have to call for the report.
May I pay for a date, Your Lordship? Your Lordship, may kindly be pleased to.
13th August.
Very grateful, Your Lordship.
My lord, the petitioner was placed under suspension, my lord, 6-1. At page 53 be seen the impugn order. Thereafter, no review, no DP, my lord. It does not reflect any DP or anything else has been done for
Yes,
causing
what
me.
has happened?
Page 53 be seen, my lord, moreover.
53.
My lord. May I read, my lord, small paragraph in pursuance to the charge sheet number so and so number so and so has been registered against Sri Kamalesh Bora, senior accountant, in completion of the misappropriation of government money, who is under regular bail in the case. In the light of above, the Kamalesh Roy, senior assistant, is placed under suspension with immediate effect as per Rule 6(1)(c) of the Assam Disciplinary Appeal Rule 1964. His further continuation in the
You are
office.
placed under suspension in February 25.
5 months. Thereafter, no renew, nothing, my lord, no DP also,
Have
man.
you received any
No.
Subsistence allowance.
Yes, substantial allowance we are getting, my lord, but yeah, my lord, no DP, my lord.
So it is not a time bound effect. Within this date, DP must be held, this date it must be sent.
My lord, lordship will see, my lord. For a moment, lordship, kindly have a look, 53. For no reason, my lord, I was placed under
What do you
suspension.
mean, no reason? 6-1.
6-1 is there, but no DP is there, my lord.
They will hold it. If they have not hold it, we'll examine that matter. What
Yes,
is done
ma'am.
with what are your instructions here?
Lordship, the instruction is that the suspension period has been extended, Lordship.
Where is it?
Yes, Lordship, that was extended, Lordship, but
By what, man?
By which order?
Lordship, that order is not annexed with with the instruction, Lordship. Further instruction is required, Lordship.
Someday we'll have to call your chief secretary to court. The OM is issued by the chief secretary and it is not followed by any of the departments. Then it is not even withdrawn. Mr. Nayak.
Lordship, kindly see the provision. This is a suspension under 6-1C. Lordship, kindly see the provision, Lordship, 6.
6-1C.
6-1C.
Yes.
If Lordship kindly read 6-1, Lordship, the appointing authority or any authority to which it is subordinate or any other authority empowered by the governor in that behalf may place a government servant under suspension. Lordship, may kindly come to see where a case against him in respect of any criminal offense is under investigation, inquiry, or trial. Where is the provision for initiating departmental proceeding?
No, but you have to read with your OM.
That is in terms of the rule, Lordship.
Well, taken out an OM.
Yes.
Either you say the OM does not include 6-1C.
No, my submission would be, Lordship, so far as the rule is concerned, this is a suspension, not in contemplation of departmental proceeding.
Suspension is not a punishment. The purpose of a suspension,
Yes.
irrespective what your rule may say,
Yes.
is to keep the man away from the office.
Yes.
So that you can conduct a proceeding or inquiry and find out whether the allegations, etc., whatever.
But in the police case, search sheet has already been filed.
But police case charge sheet is filed, then why are you keeping him under suspension?
Because the trial is pending. See,
Trial maybe.
is under investigation, inquiry, or trial.
No, but
So during the trial, Lordship, I can keep him under suspension.
then you are treating it to be a punishment.
No, if it is provided by the rule and the rule is not under silence.
It has to be interpreted. You are essentially taking suspension to be a punishment. It is not a punishment.
No, my only understanding of
Trial
the
may take 20 years.
Lordship.
Will a man be kept under suspension for 20 years?
No, then that case of prolonged suspension will come. But here suspension was only in the month of February, Lordship.
It is all right, but therefore somebody has to take a decision
Lordship.
as to whether further suspension or whether it has been reviewed. The OM is very clear.
Yes, Lordship.
OM is very clear. The OM issued by the Chief Secretary of the State is very clear as to how the suspensions are.
Yes, Lordship is right, but my understanding is OM cannot override this provision, Lordship.
That may be. then
If
you have
in
to-
terms of the rule, Lordship, I am not contemplating any departmental proceeding against the person concerned. That OM cannot make me, it is compulsion for me to initiate a department.
We will pass whatever orders are there.
And Lordship, one instruction from the Deputy Commissioner we have received, Lordship. There they have stated that the suspension has been extended, though no date has been given. That order copy has all, Lordship will,
You extended it if the rules don't provide.
yes. Lordship,
If according to you, the rules don't provide. Why?
that is what actually, Lordship, we also want to see under what provision it has been extended. And why they are reviewing this order. So Lordship will take up this matter next week,
That
Lordship.
will require interpretation of your rule. You are
Yes.
treating this rule to be a punishment. Can it be a punishment without there being an inquiry? Criminal trial is going on. If he is convicted, punishment, conviction will follow.
My understanding, Lordship, a person may be kept under suspension if the trial is going on.
Your understanding has to be that in terms of an officer of the court. There are settled law that suspension is not a punishment.
Yes, Lord.
You cannot interpret this particular rule to say that because it doesn't provide for review,
But in that situation, is there any ambiguity in this provision, Lord?
if there is not, then you'll have to read into it. You can't allow this particular rule to be interpreted, to be used as a punishment.
In that situation will come when it is a prolonged suspension, Lordship. It is here, Lordship, suspension was only in the month of February.
Therefore,
This is not even a case of prolonged suspension. And the rule is quite clear, Lordship.
This argument proceeds from the fact that you have the power to suspend, you suspend. Issue is not that. The issue is the power to suspend is with the specific object.
Lordship.
Your rules may say so, then your rules will have to be read under or interpreted.
My object is during the trial, I want to keep him away from the
Why?
office, Lord.
Why?
So that he cannot manipulate the records or something else, Lordship.
That finding has to be there somewhere.
Yes, Lordship. For that purpose, Lordship, I am praying for 1 week time. Let me have further instruction, Lordship.
You can't decide that to keep a man away from office for eternity.
Lordship, I'll have that instruction on what basis, Lordship, it was extended and whether the department is contemplating.
I think your OM is fairly elaborate.
Lordship.
There are steps directed to be taken under the OM and reports to be filed before the personal department as to who is under suspension for what period, when was it extended. That required to be taken by the department.
That instruction I may be allowed to take, Lordship. Because, Lordship, if it comes to A1A, it is clearly mentioned where a disciplinary proceeding against him is contemplated or is pending. That is another provision. There I am required to issue show cause. But so far as C is concerned, Lordship, no contemplation, no pendency.
Right, get your instruction.
Lordship.
The Government Council submits that a review has been undertaken.
So far as instruction is concerned,
Basis of instructions, the suspension has been reviewed
it has been extended and it will be reviewed further.
and the same has been extended. However, the orders extending the suspension, orders issuing, orders undertaking the review and extension of suspension is not before the, not with the State Council. We therefore seek security of the court to pray for further time to complete his instructions in this regard. Let this information be placed before the court within 3 weeks.
3 weeks, Lordship.
3 weeks.
The date may be fixed any day.
Why date? Why?
It's very difficult to get it listed.
Very difficult means we see.
Oh, load, I understand, but workload of the court also. I
No, not the load of the court. We are not concerned with the load of the court. This is a process of suspension. This man is under suspension.
Well,
you are not challenging the order of suspension on the ground that he is not authorized to be suspended. The person who has issued the order is not authorized under law. You are complaining before the court is managed under suspension for no reason. Reasons are very clear in the order. Either you challenge at the very source, you challenge it that this order could not have been passed. Yet still. Otherwise, the law will have to take its own course.
Obliged.
Will be difficult removal.
Who's for the petitioner?
M. Zain, my lord.
What is this matter?
My lord, legally, appointment of arbitrator, my lord. My lord.
Where is the petitioner? Not here.
Yes, my lord.
The council petitioner is not present. The stands different will be listed after 1 week. Mr. G. Goswami
My
has
lord.
report.
My lord, for the respondent, my lord, railway, my lord.
For railway.
Yes, my lord.
And Mr. Sharma for?
My lord,
In
they are
item number
connected.
18,
My lord,
there is-
connected, my lord. Yes, my lord, connected matter, my lord. Analogous matter, my lord. 18, my lord.
It was item given number.
Which is that?
Item 18. Mr. Hussain, you are appearing.
Yes, my lord. Item number 18, my lord.
18.
18. This case was, my lord, adjourned due to the pendency of the central organization case, my lord. Now the out of the decision has come out, my lord. So now they cannot appoint the arbitrator. Party of the agreement cannot appoint the arbitrator. And they cannot appoint their own person as a arbitrator. So there is no impediment.
We'll appoint an arbitrator.
No, my submission would be, my lord, if lordship peruses paragraph 56, the last paragraph, subparagraph 4, it says that, my lord, if the agreement falls through, then the arbitration clause also goes. So here, my lord, my argument would be the agreement falls through because the railway is not in the, what it says, my lord, I'm just reading out, my lord, that particular.
Not like this, not like this. Don't read paragraph 56 alone. You want to read, you want to argue the matter, we are ready to listen to the.
Maybe may come together, my lord. This is another.
Friday?
My lord.
We'll argue
Next week.
next week.
But this is absurd.
That's.
You are making that it is the contra submission, it is the contra proposed position in law which has been upheld by the court that notwithstanding the agreement, arbitration has to be
Yes.
called out.
That is my only argument that would remain, my lord, in this case. And I'd be arguing on the basis of the conclusions arrived at by the Honorable Apex Court, my lord.
And my lord, whether there is any pleading in this respect, my learner brother is
He
submitting.
wants to point out the judgment, let us give him an opportunity.
That-
And if you want, you can go through the subsequent judgments also.
The Apex Court,
Yes, pursuant to that. On this point,
my lord, I'll look for.
yes, list again next week.
Both them, my lord, together.
Both the matters. Is appeals that like before the court. Certain judgments of the Apex Court. Support of the contentions that if the agreement containing the arbitration clause falls through, then the arbitration agreed to by the client, the provision for arbitration also falls through. That is your argument.
That's my, in terms of subparagraph 4 of 56, my lord.
My lord.
Let this matter be listed accordingly.
After 10 days.
After 10 days. After 10 days.
Much obliged.
Yes. Item.
May it please, your lordship. Some instruction was sought from the responding council member. PHE. Yes.
19 of the.
Common water. My lord, I have received instruction. At that point of time, there was one vacancy. Oh, you need to know. The terror number. Lordship had put a specific query on the last date. That what was the vacancy position at the time? There was one vacancy at 2009-10 driver. Grade 4. Time accordingly, we forwarded to the DLC. His case is rejected by SLC.
Yes. Now the SLC is answered.
My lord, my
As per
submission is
order
not.
of this honorable court, my lord, earlier order of this honorable court, my lord, page 16. Whether that order was followed by the SLC, my lord, while considering the case of the petitioner. my lord.
Page number,
Page number 17 is the direction, my lord. Second para, my lord. In the view of the matter is remanded back to its SLC to consider the case of the petitioner against the vacancies of 2009 and 10 as recommended by DLC, my lord. The direction was specific, my lord.
and where is the rejection of the SLC?
Lordship, my submission is Lordship, SLC rejection on Lordship on 14/5/2020, Lordship. He has not challenged that order, Lordship. SLC rejected, Lordship.
Where
On
is that?
14 May 2020, kindly see the
My
page
lord,
18, Lordship.
next the order, my lord.
But where is the rejection?
18, Lordship, in the writ petition, Lordship, page 18, Lordship. Annexa C, Lordship. Annexa C, Lordship. Relevant para is Lordship on in the bottom portion, Lordship, of 18. May I read, Lordship?
Yeah.
The candidate of Sri Kamal Bora regarding appointment and compensation grant was placed before the SLC held on 21/11/15. In that meeting, like his case was not recommended by the SLC under the criteria, Lordship. It is rejected, Lordship. He has not challenged that order, Lordship. And moreover, Lordship, Chief Secretary has not been made a party, Lordship. Rejected by Chief Secretary, Lordship. No, it's not challenged. That impugn order has not challenged, Lordship.
My lord, there is no challenge of impugn order in prayer portion, my lord. For that, I will file an IA, my lord. But the thing is that, my lord, whether the SLC, my lord, while considering the case of the petitioner, with due respect, my lord, has considered the case of the petitioner, considering the order dated, my lord, 11/4/2018, my lord.
What was the cadre strength from the department on 9 and 10 and the vacancy? 2009-10, what was the cadre strength and what was the vacancy?
This communication, my lord, indicates it's silent regarding cadre strength, but the vacancy, there was one vacancy that is
That
reflected.
vacancy is also
That
for
vacancy
compassionate
of
appointment.
3 and 4 was available.
Yes.
Yeah.
We had forwarded it to the DLC. That it is vacant.
And DLC recommended it.
DLC recommended.
Then somewhere SLC. But the reason why we're asking you, because SLC says there were only 6. Cadre strength is 6.
My lord.
If it is 6, then there can't be any reservation.
Yes. That,
So that information has to come from you to show that what is the cadre strength. This they have calculated on the basis of cadre strength.
cadre strength, my lord.
So what was the cadre strength?
Let me come back with that again. I have to need some time. But otherwise, the state council is very correct. He has not challenged the SLC minutes.
Right, the challenge is not there, but then the order of this court,
My
I
lord.
think the authorities to consider it in the vacancy of 9 and 10.
Yes, yes. Yes. Understand.
They comply with. That's when the
You
earlier
have-
order, dated 13/6/2005. The Department of PH was directed. Obtain instructions regarding the vacancy position available for 2009 and 10 for compassionate appointment at basically for the court. Pursuant there, when the matter, the pursuant there, that council, Mr. T. Goy, has placed before the court a communication from the PH department which shows the vacancy position insofar as compassionate appointment is concerned in grade 3 and grade 4 for the year 2009 and 10. So from the communication, it is revealed that there was one post available under grade 3 and there was one post each available under grade 3 and grade 4 for compassionate appointment for the year 2010. So, however, the order of the SLC dated 14/5/2020, wherein the case of the petitioner was considered, wherein the case of the petitioners was considered and rejected. The SLC held that the total cadre strength for the position of the total cadre strength of the division was only six. And consequent the SLC rejected the case of the petitioner on the following ground. Perusal of the above reason does not close as combined. The case of the petitioner was rejected. The perusal of the reasons do not reflect that the case of the petitioner was rejected as suitable vacancy was not available in view of the cadre strength. Nevertheless, this court grants opportunity to the standing counsel to place before the court the cadre strength of the division / the department in the year 2009 for working out the available vacancies for professional. Let these instructions be placed again on the court within 3 weeks.
My lord, date may be fixed now.
3 weeks, it's again 13 August.
Deeply obliged, my lord. May I please address? What is the family pension? And maybe he in the lawsuit last night, he called me that he is
Sorry, petition is the file reply, Lordship. Last order dated 21/3/25, Lordship. Petitioner wants to file reply, Lordship. They have not yet filed.
Nothing remains to file, Lordship. But I am not going to file.
You are not going to file.
Yes, sir.
Then family pension.
Lordship.
What has happened?
Retirement benefits.
Yes, madam.
Why is it not been released?
In this case, Lordship, D. Upamanyu is appearing and he is on in bereavement, Lordship. So Lordship may fix the matter after 2 weeks, Lordship.
Mr. D. Mia, counsel for the MSD Bora, the council who is assigned with the in bereavement. So that will be different weeks. It's again on weeks.
Obliged, Lordship.
Obliged.
May please, your worship. The petitioner has sought for some adjournment. The petitioner sought for an adjournment.
There is nobody here.
To file an additional affidavit on the last occasion.
And appears for the petitioner. Mr.
A. Dekha.
A. Dekha appears for the respondent. It's taken after 3 weeks.
This petition has been filed on ground of default of the respondent to act as per the requirement of the agreement, and this is called by your lordship own judgment. Parties are same, facts are similar.
Yes, Mr. Gupta.
My lord, can be appointed, my lord. No.
Yes,
Same,
covered, yes.
Only the issue, my lord, regarding the 20%, my lord, arbitrability.
That has
may
been
be-
mentioned in that.
Yes. That will be decided by the arbitrator.
Only contract agreement is different, my lord.
Who is the arbitrator?
My lord, same name may be, yes, similar facts are there.
Because after this SBI judgment, my lord, Krish spinning, my lord, I think. Everything has to be decided by the.
Mr. Gupta is there.
Hmm.
Contract number will be different.
Yes, my lord, different.
And all the clauses are same.
Almost causes are same, date is different.
And work order is different.
Different.
And what is the work?
Work, my lord.
Same work.
No, my lord, different work, different contract agreement. At page 38, my lord, contract agreement is there. Both are relating to the Mizoram project.
That Mr. Reed for the CGC for the response. And the appointment will be of the same person. Next year. Where is the other matter listed?
No, already.
Appointed?
No, my lord. The notice has been issued to the proposed arbitrator.
When is it listed?
After 2 weeks, it was fixed, my lord.
That is after the listed along with 30 of 2020.
Yeah, yeah.
My lord, before starting my friend, my lord, I like to highlight something. This, I'm widow, my lord, having a minor child. Owing to pending this case for last 5 months before this honorable court, I'm not getting pension and I'm in great troubles, my lord, to maintain my livelihood, my lord. So on the face of the notification of the government, Pranam Act, and other notification passed by the government, my lord, she will get my mother-in-law will get only 10%. And I'm agreed to give it, my lord. I have no dispute on that. Kindly dispose of the matter, my lord. This is my humble submission. I'm giving circular government, all circular, my lord.
Kindly peruse the earlier order, my lord. Honorable court directed the respondent, my lord, official as to argo regarding my lord process of compassionate family pension. And compassionate family pension is not a salary, my lord. Regarding Pranam Act, my lord, salary has to be apportioned, my lord. But in compassionate family pension, my lord, it has sanction, my lord, like the, my lord, normal pension or family pension, special family pension.
You are the, who is the mother? You are the
I am
mother?
the mother.
He is for mother, I am for wife.
For wife.
I am for wife.
I take it.
My husband died in harness.
Whose name was mentioned there in the pension paper?
Pension paper, I have got pension, other benefits, but not salary I am not getting. So pension paper, my name has been mentioned, so I have got pension benefits, my lord.
You've got the pension benefit.
Pension benefits, but owing to pending this case, I am not getting pension. Monthly pension I am not getting. And my lord, if I argue the matter, your lordship will be pleased to see the Pranam Act, first of all.
So let us first hear the petition.
Oh,
we hear you.
My lord, my lord.
And what has the government got to say?
Lordship, he will be entitled for 10% as per this Pranam Act, Section 8,
Who will be
Lordship.
entitled?
The mother of the
Mother-in-law.
10%.
That is the writ petitioner.
Lordship.
Writ petitioner. And I am agreed to give it.
And there is an order of this court, of this honorable court also, Lordship, on similar lines, Lordship. Earlier, Lordship, in the Pranam Act, only salary part was included, but later on, by an amendment brought to this Act, Lordship, the compassionate family pension has also been included, Lordship, who die in harness.
As per notification dated
And those
29.
dependent parents, Lordship, as per Section 8 of the Pranam Act, the apportioned amount they are entitled, Lordship.
As per notification dated.
Under what are the provisions? This program is the parent responsibility.
Yes, Lordship.
This is meant for government service.
Yes, Lordship, who die in harness, Lordship.
Which section is it?
Sir, government employee, as per Amendment Act, my lord, after all, amendment has come to the legal wife. Government employee, legal wife as if to a government employee. In compulsory family pension act, my lord, by Amendment Act. Now, wife as if a government employee now.
Give us a consolidated act.
Notification 29 September 2021, my lord. Amendment of section 2. Kindly have a look, section 2(1). 29 September 2021 notification. In the Principal Act in section 2, in clause B, in first line, after the word employee, the words and the amount of the commission.
You first take us to the principal act. Let us see what does the principal act say.
Principal Act.
Principal Act 17 Act, my lord. And 17 Act, my lord, kindly peruse, my lord, section 8. Section 8, my lord.
No. This is meant for whom? You said it is for dying in harness.
No, my lord, it is the.
Who died in harness?
It is, my lord, Pranam Act more for the purpose of salary, my lord, during the course, my lord, lifetime of the employee, my lord. And it specifically mentioned, my lord, section 8, my lord. If the designated authority consider appropriate, it shall sanction the apportioned salary of the employee. And I seeking, my lord, apportionment of compassionate family pension, my lord. And therefore, my humble submission, it is not covered under the Pranam Act, my lord. As per compassionate family pension scheme, my lord, the compassionate family pension, my lord, sanction in the same way as normal pension or family pension, my lord. 5 notification dated 5th July 2018, my lord.
Where is the notification?
My lord.
How many years did he complete?
My lord,
Before his death, how many years?
my lord, he died in harness on 11/6/2023.
After how many years of service?
My lord, he joined in 2011, my lord. After 12 years of service.
For how many years till he attains superannuation?
My lord, what the process was.
It- 17 years like this, my lord, actually.
Who are the persons eligible for the family pension?
My wife is wife, my lord. I'm wife, legal married wife, my lord, I'm spouse, and I'm having a minor child, school going child, my lord.
Under what criteria are you, is it available to you?
My lord, the definition of family, your lordship will say, I have not brought the
143, rule 143. my lord.
definition of family, first legal here is wife.
Then
Amendment.
Thereafter, minor child. And if wife died, then minor child and the unmarried daughter will get the pension 50-50. But wife will get full salary of the employee in compensatory family pension, my lord, if the employee died in harness. This is, and thereafter Pranam Act has been passed, my lord, and if the deceased wife does not look after the parent, that is the mother and
where are the
father-in-law.
amendments to the Family Pension Act?
My lord, kindly see page 49, my lord.
Page 49.
49, my lord.
Pranam Act is very clear, my lord.
In note 2, after clause C, the following new clause D shall be inserted. If the family pension recipient does not divide the amount among the other beneficiaries in equal shares.
So who are the beneficiary? Who are the-
Beneficiaries, my lord, father, mother,
Where?
also.
Under what?
As per rule 143, my lord.
The 143 leaves you a criteria.
My lord, it is the, my lord,
Will include the
family members.
wife in case of a male officer.
Wait, thereafter, my lord, minor son, my lord, minor daughter. If not, my lord, then father, mother also, my lord.
Where is that?
My lord, amended rule in the year 2016, my lord, it is amended.
Is it available here?
My lord.
Even school माता पनि मध्य स्वीकृति पनि गर्छ हसोली we don't हसोली जाति आसे manage in cases where there are 2 or more family members, son unmarried dependent daughters. What he's speaking about son and unmarried daughters after the death of the widow, that will be shared 50-50. But my landlord friend, what he's saying, I do not understand.
Page 161, my lord. Last, my lord. Amendment.
amendment.
my lord. And next come, my lord, next, my lord. Prior to, my lord, 2015, my lord, father, mother has not included in the members of family, my lord. Subsequently, it was included by this amendment.
You're referring to which? Note 2.
Note 2, my lord.
Note 2.
See, there are note 2 after clause C,
Yes.
D clause inserted, my lord.
No, but note 2. You're saying that wife and father, mother, everybody has to be given under the family pension.
No, my lord, I am seeking apportionment of the, my lord, share, my lord.
What provision?
Apportionment, my lord, page 49, my lord, of my writ petition, my lord. It is the amended act, my lord. Page 49.
Page 49 was I should.
Page 49.
Page 49 of my writ petition.
Yes.
Last, my lord, last column.
This is the note 2. This is the note 2 which you are showing in the book.
My lord, D has not included, my lord.
It is included.
D, my lord.
Yeah.
My lord.
Included. Division of the pension.
My lord.
It is included here. But this is. This has to be read with you cannot read the note 2D in isolation. It has to be read with note 2.
My lord.
You read note 2?
Note 2, my lord.
Do you have note 2? No.
No.
তোমার কালেকশন করছো যদি মিসগাইড করি আছে ফটো মিসগাইড করি আছে
একটু
নোট টু স্যার হ্যাভ কালেক্টেড which is related to unmarried daughter and son. D has come on the below. Prior to the note to start from unmarried daughter and son. I've seen my lord.
Well, note 2. In cases where there are 2 or more family members, minor son, unmarried dependent daughter present at the time of death of widower, the family pension as admissible.
At the time of death of the widow.
My lord.
Of the widower.
Death of the widow.
This is to take care of a situation where the widow who was receiving pension died.
My
What
lord.
happened?
Divided in all of the equal share in the.
It does not mean that you have equal claim. It is only in this event that the pension is to be divided.
My lord.
Yes, government.
Lordship, I have also submitted one order of this honorable court, 1728 of
Go
24.
to orders. First tell us what is the provision. What does the
Lordship,
provision?
10% of the apportioned salary 10% of the apportioned salary may be
Given to the read petition.
given to the read petitioner. Lord. As per, this is the settled position, Lordship. As per the
Monthly
Pranam Act,
compassionate pension.
monthly
Compassionate
compassionate
pension.
family pension, Lordship.
So under this compassionate family pension, what is the entitlement? What is her entitlement?
10%. For now.
As per the Pranam Act, Lordship, Section 8. Lordship may come to Section 8, Lordship. Quantum of apportioned salary and ceiling thereon, if the designated authority considers appropriate, it shall sanction the apportioned salary of the employee to his dependent parents, Divyang siblings, within a period of 90 days as mentioned in Section 7, and issue directions to the drawing and disbursement officer concerned, clearly stating that the apportioned amount to be paid on monthly basis directly to the dependent parents with effect from the succeeding month of the date of the order, provided that such apportioned amount shall not exceed 10% of the monthly gross salary being paid to the employee, except in exceptional cases only where it may go up to 15% of the monthly gross salary. This is the position, Lordship.
Now for that, there has to be an application by the petitioner.
Lordship.
Section 8, is it on the basis of an application?
My lord, on the basis of application. Section 7. Upon
Yes,
receipt of
Lordship,
such
because
application.
the dependent parent has to apply for the
Yes.
compassionate family, that
So you take
apportion.
an application.
My lord, I may be allowed to, my lord.
But come to the petitioner has approached this court saying for apportionment of the share of monthly compassionate family pension.
Application given.
Of the share, which is allotted to the respondent number 8. So petitioner is the mother of late Kiron Kangmai, who while serving as a constable under the commandant 13th Some Police Battalion, Lilabari, the district of Kopil, died in harness on 11/6/2023. So the respondent number 8 is the widow and daughter-in-law. Is the widow of late Kiron Sangmai and the daughter-in-law of the petitioner. Better. Although the initial claim made before this court by the petitioner was a share of a pension in terms of Rule 143 of the Assam Pension, Assam Services Pension Rule 1969. However, during the course of the argument, counsel for the petitioner, as well as the counsel for the respondent, have submitted before this court that the prayer of the petitioner can be considered under Section 7 and 8 of the Assam Employees Parent Responsibility and Norms for Accountability Act 2017 or
7 and 8 for
disbursement of 10% of the salary which was drawn by the deceased employee. the counsel for the petitioner submits that he be granted liberty to file an application before
Respondent number 6.
respondent 6, who's the designated authority. Respondent 6 or and or the appropriate designated authority as specified in terms of the Act of 2017, and thereafter the designated authority will consider the application and thereafter pass speaking order for apportionment of the salary of the deceased employee to the petitioner within a period of 90 days as prescribed.
My lord, kindly 90 days, my lord, very short time, may kindly be given, my lord.
90 days as per rule.
Under such, in that view of the submission, in view of such submissions made, the writ petition stands disposed of, permitting the petitioner to file necessary applications under the so-and-so Act 2017, praying for apportionment of 10% of the salary of the deceased employee. And a further direction to the designated authority to consider the application and pass appropriate orders and provision rules within the prescribed period of 90 days from the date such an application is received. This petition accordingly stands disposed of in terms of the.
Obliged. My lord, section 7 and 8, both, my lord.
Yeah.
Deputy obliged.
May please your lordship, in this matter, we need 10 days time to file our affidavit.
My lord, in this matter also I have some submission, my lord. Recently, my lord, they have released one provisional pension for the month of 38. When is it?
38.
Sorry, sir.
Yes.
Lordship, 10 days time to file our affidavit, lordship.
Yes. Counsel for the APS.
Lordship.
And a speech Sharma, with further 10 days by the. There may be not allowed, disputed by. This matter again after 2 weeks.
Let him please fix a date.
You may like to file a rejoinder.
Yes, sir.
Then the matter be listed after 4 weeks. You know, listed only then. 18th of August.
Much obliged.
39, lordship, I need only 2 days lordship accommodation. Monday lordship can dispose of this matter.
Lordship,
On that day lordship can
that
dispose of
day
matter.
also lordship, we sought for time again and again.
Only one or 2 days I want to that. I will install that
And-
review has not been done.
That
Eventually,
lordship, now they cannot, my respectful submission, lordship, now they cannot improve their case. Because the statutory compliance
not-
that has
I
been
need now
done in
Monday,
this
till
case,
Monday.
lordship. And my case is covered case, lordship.
You will consider on Monday.
Monday,
Lordship, then let it be on Friday, lordship. Let it be, he's asking for 2 days, let it be on
What are
Friday.
you challenging the suspension?
Yes, lordship.
He is not terminated. Is he retiring in?
No.
He's at the verge of retirement,
When
lordship.
is he retiring?
He is another 3-4 years left for
3,
his.
4 years. We can have it on Monday.
Monday lordship can dispose. On that day lordship can dispose it.
Monday.
Lordship, let him,
No, I have
that he will not seek for further adjournment.
No, lordship. On
That
that
may
day
be
lordship,
taken
Monday
care
can
of,
dispose of
At
it.
the request made by the council for the revenue department, Mr. Stand referred to be listed on Monday, on which date an attempt will be made to dispose of the writ petition on the basis of such instructions as may be placed. Council appeals for the petitioner, MST so. Monday.
Objection.
We refer it to mediation.
Also, we are not inclined, we have talked with the petitioner also, they want to fight it out.
So whether you are inclined or disinclined, we'll refer it. Why do you want to keep it pending? What is the?
No, the last occasion, actually, we were ready on the last occasion also, Your Lordship, the opposite party were not present. It is reflected in the order sheet.
Right
Lordship
of
would
promotion. What are you seeking?
is seeking promotion only. Notional benefit of the promotion.
Notional benefit.
Yes, sir.
He has already retired.
I understand now, Lordship, after this Mr. Justice Matters judgment, it has become difficult, but we would like to try it. So after Justice Matters judgment on promotion, it has become the scope has become that very even in case of notional benefit also. But we would like to the petitioner want to.
Like once the law is laid down, what is there to be decided?
No.
Can a judgment of the Supreme Court be?
No. I'm not on that. It is limited our scope, but there are.
You are not considered, you are not in the zone of consideration at the time you retired.
We were in the zone of consideration. When a lordship, there was an order of this High Court also for consideration, and the time frame was given in that order. The 3 months time frame was given to consider me. That was also not done in for manner, Your Lord. An order of the High Court cannot be. Lordship may fix a date in the month of August and we'll do the hearing. Your Lord.
Let us refer it to mediation. Thereafter, if it doesn't work, it will come back.
Lordship, it's 2018 matter.
Therefore, it's pending since
We'd like to take
2018.
our chances before Your Lordship. We'd like to take our chances before Your Lordship.
No, chance before me would be dependent on the laws governing the issue. You are governed by the law. When the law is against you,
I understand it has limited our scope, Your Lordship, but there are other issues outside this matter.
all right, after 3 weeks, after 4 weeks. This matter after 4 weeks. They are made by the council for the petition.
Date may be fixed, Your Lordship.
An attempt shall be made to hear the matter. The next day. Rule has been issued here. Four weeks. It is taken.
Obliged.
29.
In this,
28.
Lordship, in this matter, the commissioner has written to the
Yes.
The commissioner has written to the concerned BDO for submitting the earlier proposal.
Let it be referred to mediation. This matter is referred to be placed before the Bombay High Court. Mediation. Referred to be processed for mediation by the Bombay High Court.
Number 13.
Yes.
Lordship, kindly pass over the matter for a time.
Let it go to the mediator first.
Mediation, let it go to mediation. Let it be referred to mediation. That will be referred to mediation. To the joint committee. For the place of mediation.
One.
In this case, my lord, PP already, my lord, PP already sanctioned, my lord.
What is sanctioned?
My lord. PPO, my lord.
DPO sanction,
Sanction, my lord, but not released by the treasury of, my lord.
it will be released.
My lord.
When was it sanctioned?
Sanction 24/4, my lord. April, in the month of April.
Assistant.
Yeah, then let it be placed before mediation by this time,
My lord,
maybe released.
my lord.
It is submitted, that the PPO has also already been on 24/4/2025. However, the amount does not yet become the before the issuance of committee for being placed for mediation. Yes. Ms. Roy and Mr.
Item 32, my lord, pension probably pending before the AG, my lord.
Pension proposal.
Pending before the AG. my lord.
AG, who is appearing for AG?
I am preparing
What are you saying?
instruction awaited.
Instructions awaited. Right, this matter be. How long would you require instruction there?
Next week,
Next week? That will be listed next week on the request made by Mr. Medi.
KK Medi on behalf of SK Medi.
Mr. What Medi?
KK Medi.
KK Medi. Appearing for the accountant general. Submits that the pension proposal has been processed, but he would like to update his instruction. List next week. Yes.
MD on behalf of sericulture.
Or
Aadhar for sericulture.
the number
1 and 4.
1 and 4.
S. Boro on behalf of RV Bora for respondent number 7, 8, and 9.
As for respondent 7 and 8.
7, 8, and 9.
7, 8.
And for respondent number 2, S. Bora.
As for respondent.
Obliged.
My pleasure, Lordship. The petitioner has received the amount, GPF amount, on 4th March.
You have received?
Yes, Your Lordship. Amount of 4,59,852.
So nothing further to.
Yes, Your Lordship.
Counsel for the petitioner on instruction submits that the GPF amount amounting to rupees
4,59,852.
4,59,855 has been received.
With interest.
With interest. And therefore, no further cause survive present petition. Mr. C. Borua for accountant general. And Mr. K.K. Goswami for
1, 4, and 5.
1, 4, and 5. The case for the respondent, this technical respondent. The petition stands closed, disposed of. No order is proposed.
Deeply obliged.
You, okay.
34.
Maybe your respondent number for all the respondents have filed affidavit of opposition, my lord. 6 time may be granted.
Lordship, it's not a matter to be sent before the mediator, Lordship.
Dismissal
It's a
from
disciplinary proceeding matter and central government matters.
You're against what dismissal?
They have filed against dismissal.
Dismissal.
Yes, Lordship.
This petition has been filed to challenge the order of dismissal by the petitioner. Pursuant to the disciplinary proceeding initiated. So, since the order of dismissal is under challenge, matter cannot be resolved through mediation. So, further, are you finding any
I have already filed affidavit.
pleadings are complete? Let the matter be listed for hearing.
Lordship, I will be allowed to file our return judgment.
Huh?
Rejoinder,
Rejoinder you want to file?
Lordship.
You submitted that but the affidavit is not here. It is submitted by the learned CDC that the affidavit has been filed
On 26/6.
on 26/6, which the learned counsel appearing for the petitioner seeks liberty to file rejoinder. Let the matter be listed again after 4 weeks. The registry will press out the affidavit stated to be filed by the respondent that connected to the case record.
Obliged.
35.
I please, Lord. My lord, this is pension matter, Lord.
Now, pension,
My lord, family pension.
so we'll send it to mediation.
My lord.
Matter be referred for mediation, registry to basically for the committee for facing the matter for mediation. Mr. A. Rahman for the petitioner. Mr. Who's appearing?
I'm for respondent 4 and 5.
Mr.
E. Hazarika on behalf of SRR.
Yadoriga appears on the for 4 and 5, and it's photo T for
1 and 2.
1 and there's Purva for.
Respondent number 3.
We are sending it for mediation.
36.
Make me your lord. My lord,
Mediation.
my lord, in my humble contention, this matter perhaps may not be sent for mediation because I am, my lord, praying for my entitlement as per Rule 21. Notice was issued, I am paying for revision of my provisional pension and settlement of my final pension.
Lordship, here I am waiting for my instruction, Lordship. Because it is the matter after 3 weeks.
There was a different departmental proceeding, I have been exonerated.
Heard Mr. D. Chakraborty, learned counsel for the petitioner, Mr. N. Upadhyay for the which department?
Irrigation department.
Irrigation department. Praise for 3 weeks by the time to complete its work. The council for the petitioner submit that the challenge in the writ petition is with regard to
Non-payment of provisional, revision of provisional pension and final settlement of kind.
is regard to seeking a direction for to the respondents for settlement of final pension as well as for the revision of provisional pension paid to the petitioner. It is submitted that this matter cannot be resolved through mediation via a decision of the court. Accordingly, matter be listed after 4 weeks.
Lordship.
May we get a date, man?
4 weeks. Obliged.
4 weeks. You want the date?
Mine,
Placed on 20 August.
20th of.
Obliged.
Item 28.
May I please, Your Lordship? My lord, in this matter, my lord, my client has communicated, my lord, a letter, my lord, on 2nd June 2025. They have released provisional pension for the month of June 2025, my lord. My learned friend, same. Yes. But so far as, my lord, it is actually not clear, my lord. I received my instruction from my client, my lord. I'm seeking time for, my lord, 3 weeks time for filing additional affidavit. Detailed calculation I could be brought before this court, my lord. I'm 3 weeks time, my lord.
Counsel for the petitioner heard with counsel for the petitioner submits that the petitioner has been communicated with an order dated 6/2025, whereby provisional pension has been moved to be released.
June 25 only. June 25 only. The provisional pension release for the month June 25.
For the month of June. He therefore seeks some time to complete his instruction.
And additionally,
and to file necessary affidavit into it, right? Council prays for 3 weeks time.
3 weeks, my lord. 3 weeks, 3 or 4 weeks, my lord.
HR Das appears for
Rest number 1, 2, and 3.
1 with
Myself 4 and 5.
Raman for 4
4 and 5 assisted by Irfan Atif.
Senior counsel assisted by.
Irfan
Lordship, I am on VC, I Hasib.
How are you assisting him through VC?
Lordship, I have briefed him on the matter.
The council, main council.
MS.
Engage council, yes.
Assisting.
We have one virtual and one actual. face this matter after 4 weeks.
Yes, my lord. Deputy obliged.
Grateful, Lordship.
On hearing item 37.
Yes.
May I please, Your Lordship? Your Lordship, the petitioner who was being transferred to Khatkati, before shifting to Khatkati, he has shifted his family by his own accommodation in a rented house in the previous allotted posting, Your Lordship. That is in Allahabad, Your Lordship.
What are you challenging here?
We are challenging that he has not received house rent allowance, the additional house rent allowance while he was staying in Khatkati, Your Lordship, during the period from 2013 to 2017. And based on OM, Your Lordship, that is
We
dated.
posted for hearing on 22nd. 22nd, next Tuesday.
22nd, my lord, I am not.
29th. Let it be on 22nd. You are there. You ask somebody to be there.
24 or 20.
24. All right. 24.
Here is only a small issue, my lord. What happened, my lord, this, where the petitioner was, my lord, initially posted, my lord. My lord, after transferring to the northeast, my lord, he shifted his own, my lord, to his family to rented house, my lord. And now, thereafter, my lord, in a new post in the northeast, my lord, in Khatkati, my lord, he asked for the additional house rent of that place also, my lord. That place original where he was, my lord. He was posted earlier, my lord.
Where was he posted at?
Earlier, my lord, in Allahabad, my lord.
Allahabad.
Allahabad, my lord. And thereafter, my lord, he posted in Khatkati, my lord. As per his claim, my lord, his own, my lord, he shifted his family to the rented house, my lord.
Where?
In Allahabad.
In Allahabad.
So, my lord, there is one provision, my lord, if he is in earlier posted in private residence or not in quarter, my lord, then he transferred to the other place, my lord, he will get the house rent in that place, my lord. Here his own shifted his family to the.
We'll come back in this, we'll take up the matter again. That's 2 p.m.
Yes, my lord, it's very small, my lord.
2 p.m.
Yes. Only that, whether he is an